Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself. And finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today we are talking about Airbnb and all kinds of short-term renting in the wake of the controversial New York City Local Law 18. Today's pod will be longer than our typical 10 minutes because this is a big topic for New York City. We're going to be talking about the case brought by Airbnb against the Mayor's Office of Special Enforcement that upheld Local Law 18, but we're also going to cover in the Tenant Takeaway segment two important things. First, we are going to talk about which New York City tenants can still do short-term renting legally and how they can do it legally in their New York City apartment. Second, we are going to be talking about how tenants can stop or attempt to stop a neighbor in their New York City apartment building from doing illegal short-term renting. So let's start, as we always do, by setting the stage with some context. First, we define short-term renting. Short-term renting means renting for less than 30 consecutive days. Again, short-term renting, it means renting your apartment for less than 30 consecutive days. So 30 days or more, anything like that has nothing to do with what we're talking about today. 5 years ago, I made a class for the tenant learning platform called How to Do Short-Term Renting Like Airbnb Legally in Your New York City Apartment. The class had a 40-page book. It had 8 video lessons and an online quiz, and I even hired actors to act out little scenarios. I wrote little scenarios that demonstrated important concepts. I was so proud of that class. I just thought it was the best thing. I listed the class for $125. I came up with that price because I had read that average New York City tenants made $125 per night doing short-term renting. So I thought surely people would line up to pay me $125, just one night's profit, to know how to do short-term renting legally. No one bought the class. In 5 years, I think I sold 25 classes, and at some point, I dropped the price to $25. Then, when Local Law 18 was enacted, half the material in the class became obsolete anyway, so I took the class down. My friends told me what was wrong. I was like, wow, the class has a 40-page book and 8 video lessons and a quiz. And my friends were like, yeah, it's 40 pages and 8 video lessons and they have to take a test. Michelle, nobody wants to get a master's degree in Airbnb over here. Look, I always say that the law is not simple and it's not a short story and people deserve the truth. But that criticism of me there is probably valid. Back then, I was more experienced in creating content for other attorneys, for sophisticated real estate professionals, for bankers, for brokers, for appraisers. I didn't really have my average New Yorker who just wants to participate in the sharing economy groove going back then. Fair enough. But in retrospect, I realized the really big problem with that class was the fact that no one really needed to know how to do short-term renting legally in their New York City apartment because nobody was doing short-term renting legally in their New York City apartment, and there were very few consequences for not doing it legally. The only way to do short-term renting legally in New York City, and this was before Local Law 18, but it's still true after Local Law 18. The only way to do short-term renting legally in New York City is you need to be home while your guest is in your apartment. So if you're away in Europe while your short-term renter is using your apartment, you're not doing short-term renting legally in New York City. If you're in Philadelphia while your short-term renter is staying in your apartment, you're not doing short-term renting legally in New York City. If you are just spending the night at your boyfriend's apartment 1 block away, you're not living in the apartment while the short-term guest is in your apartment, then you're not doing it legally. Also, you're not allowed to have more than 2 guests. Again, that was before local law 18, and it's still true today. And if you had one roommate, you could have one guest, only one guest. Also, you can't do short-term renting if your lease forbids it, and there were other restrictions as well. Also, there were these professional operators. That's the name I gave them. I called them professional operators. These were people who were not tenants at all, who would go all over the city renting apartments solely for the purpose of putting them on Airbnb or some other booking service. And all of that was illegal. And it was causing a lot of havoc for regular New York tenants whose apartment buildings were suddenly turned into hotels that weren't run in a professional manner. They weren't run at all. So you had strangers wandering the hallways and the common areas looking for where they were going, smoke alarms going off because people didn't know how to use somebody's toaster oven the right way, wild parties. Also, many people suggest that illegal short-term renting pulled thousands of apartments off the market for regular housing at a time when New York City had a housing shortage, still has a housing shortage. Before local law 18, the onus of enforcing the law was really on landlords and neighboring tenants. So tenants had to complain about their neighbors doing illegal short-term renting, and landlords had to start expensive, lengthy eviction cases against the tenants doing the illegal short-term renting, and or the city had to dispatch an inspector to a suspected illegal short-term rental gig, and then the inspector would have to gain access, write a ticket, then the violation had to be adjudicated. And here's the funny thing. The ticket basically got the landlord in more trouble than the host a lot of the times, because the tenant could also be issued a ticket, but if the tenant was a professional operator, they would just disappear, whereas the landlord is stuck with the landlord's building. So there were really 2 problems before local law 18. First, the people who were engaged in illegal short-term renting were not the ones feeling the consequences of short-term renting. And second, any consequences that they did feel came way after the fact. So local law 18 changes things. And I'm going to link to the law, obviously, in the show notes. What local law 18 does is this. Local law 18 makes it illegal for anyone to do short-term renting or to advertise for short-term renting without what amounts to a license. The apartment needs to be registered with the Office of Special Enforcement. But here's the catch. Not every apartment is eligible for registration. Many apartments are just automatically disqualified from obtaining a short-term rental registration number, and we'll talk about those in a minute in the tenant takeaway segment. Also, even if your apartment is eligible for registration, it's somewhat difficult to obtain a registration for short-term renting. There's a lot to it. Also, there are fines that can be levied against the host for violating the law and against the booking agent. So the booking agent is like Airbnb, VBRO, Booking.com. The fine for the host can be 3 times the revenue generated from the illegal activity for up to $5,000. And there are new record-keeping requirements and reporting requirements for both hosts and booking agents. So what we have here with local law 18 is stricter laws, yes, about who can do short-term renting, but really it's the enforcement portion that makes local law 18 so significant, and that's why Airbnb doesn't like it. Local law 18 moves enforcement way upstream. So it used to be that people could do illegal short-term renting, and if they got caught, then there might be consequences. But like I said earlier, not for the booking agent and not any more severe for the tenant than for the landlord. Now, because it's a registration thing, you can be wrong even before the guest shows up, just by virtue of the listing. And so can the booking agent. So the booking agents like Airbnb are just not going to even take your listing anymore without a registration number. And even if you find another way to book a guest, if you get caught now, there's a fine that you as the host get hit with. And I also think now that exposure to eviction, if you do illegal short-term renting, is higher because there's less that the landlord needs to show to win a landlord and tenant case. There's a clear violation of the law, and most leases make a violation of the law in and of itself a breach of the lease. And the new law comes with a New York City agency that's empowered to enforce it more seriously. The Office of Special Enforcement has a complaint portal. They can issue subpoenas, their record keeping requirements for hosts and booking agents, and they can just not renew your registration. Here's the interesting thing that I've noticed in the press, however. The press has been making it sound like short-term renting in New York City is completely outlawed. And it hasn't been completely outlawed. It's just been greatly limited. And that's the thing. When a marketplace has many of its suppliers suddenly derailed by regulation, what does that mean? That means that any of the suppliers left standing in the marketplace have an amazing opportunity. So if you're one of the New Yorkers who can register your apartment and do short-term renting legally, I think you could probably make some very nice money. But I'm not going to repeat my previous mistake with the 40-page book. Here's what I've done. I've created a one-sheet guide to doing short-term renting legally in your New York City apartment. Now, there's a lot to this, but I think this one-page flow sheet kind of puts everything in context, and it has all the citations and all the links. So it's just a nice place to start. It's in a flow chart format. And what am I charging for it? I'm charging $5. The truth is, I'm not going to get rich off your $5, but I am a podcaster over here now. And when a podcast gets popular, the podcaster sells merch. They have a funny little saying from their podcast, and they put it on a hat or a tote bag, and people pay $35 for it. So my merch is only $5, and it's not a t-shirt or a mug. It's information. But to show you what a truly terrible businesswoman I actually am, in the Tenant Takeaway segment, we're going to go over that one-page resource about short-term renting legally in New York City, and you're going to know everything that it says anyway. So the only people who will be giving me $5 for it are people who are really eligible for short-term renting and really serious about doing short-term renting legally in their New York City apartment. Something else has also happened since the new law passed and was upheld by the court. People are calling me who pretend to be regular New Yorkers, but I can tell they're professional operators. These are people just looking for a way around the new law. The ink isn't even dry, and they're looking for ways to do the next scam. Well, I certainly am not going to be working with these people, and it made me think that there's another resource that I needed to create for New Yorkers. So I also made another resource, and this is for people who are aggrieved by what they suspect is illegal short-term renting in their buildings. And for this one, I'm not charging anything. It's free. It's on the short-term renting section of the podcast website, along with the other thing, the $5 one for how to do it legally in your apartment. I'll put all that in the show notes. So now we have our stage all set. Let's talk about today's case. Today's case is in New York State Court, and it is Airbnb versus the New York City Mayor's Office of Special Enforcement. I will put a link to the full text of the case in the show notes. In this case, Airbnb is challenging the rules made by the Office of Special Enforcement that support Local Law 18. Airbnb makes many arguments against the new rules, and I'm going to examine the one that I think is the strongest. Airbnb says that the new rules will create too much work for it. It would be required to gather and verify a lot of information that it never had to worry about before. This will mean that Airbnb must hire more people, and that work would have to be done for each listing, even if Airbnb never makes any money on the listing, because not every listing becomes a booking. Airbnb characterizes the rules as too extreme. The court refused to strike down the rules. The court said that the rules were a rational way to address the problem of illegal short-term renting in New York City. The court noted, and I'm quoting, quote, "The Office of Special Enforcement has largely relied upon complaints and subsequent inspections. Undoubtedly, that is an entirely inefficient and labor-intensive way to address the problem. The registration system proposed under Local Law 18 and the subject rules makes it easier to identify many illegal short-term rentals before they are listed on Airbnb and creates a financial incentive for Airbnb and hosts to make sure they follow the law." Close quote. So as to Airbnb's insistence that it will have to devote more resources to ensure it's following these rules, that was not so compelling to this judge because part of the court record revealed that Airbnb's revenue in New York City in 2022 was $85 million. And what seemed to really bother the judge was that, quote, Airbnb did not sufficiently dispute the city's point that much of Airbnb's revenue derives from illegal short-term rentals, close quote. Thus, the court denied Airbnb's request to strike down the rules. Now let's talk about what's left after Local Law 18. Who, meaning what tenants, can still do short-term renting and how can they do it legally in their New York City apartments? That's what we're going to cover in the Tenant Takeaway. But first, housekeeping. This is not legal advice and I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it's terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Email us with your questions to answer on the pod. And if you like our work, please give us the 5 stars and put this podcast on your socials because you might not need this information today, but somebody else might. It's time for the Tenant Takeaway. Tenant Takeaway time. We are going to be going over the resource that I created for the Tenant Law podcast website. There's a link in the show notes entitled How to Do Short-Term, meaning under 30-day renting like Airbnb, legally in your New York City apartment. And this thing is set up as a flow chart. This is not meant to be the be-all and end-all of everything that you need to know to do short-term renting, but it's a very good place to start. It's a good way to organize your thoughts. It's a good overview. So the way we're going to do this is we're going to pretend that you're someone who wants to do short-term renting legally in your apartment, and I am going to ask you questions. So question number 1, is your apartment in the New York City Housing Authority? Are you rent stabilized? Are you in a private housing finance law project? Or is your apartment illegal? And by illegal, I mean like an illegal basement apartment in what's supposed to be a 2-family house, that kind of thing. So if any of that's true, NYCHA, rent stabilization, illegal apartment, unfortunately, you have to go on the off-ramp right now because short-term renting is not something that it's legal for you to do in your New York City apartment. The elimination of rent-stabilized apartments from short-term renting is the elimination of 1.1 million potential units for short-term renting. And by taking out NYCHA, you're taking out another 40,000. So yes, short-term renting is severely limited. But if you're not rent stabilized, you're not in an illegal unit, you're not NYCHA, you're in a free market apartment or maybe a co-op, then we can go along to question 2, which is, and this is going to eliminate a lot of people as well, but let's do it. Does your lease prohibit short-term renting? Or is your building on the New York City prohibited buildings list? Let's take those one at a time. When you look at your lease to see if it prohibits short-term renting, you really need to scour it. I noticed that New York City residential leases are getting longer and longer. They're like a pile of paper. You need to really read all of it. And that especially includes the riders that come with the lease. And on your renewals, the riders that come with your renewal, because it can be tucked in there somewhere. The New York City Prohibited Buildings List is a new thing that comes along with Local Law 18. If a building qualifies, a landlord can get the building onto this prohibited building list via the Office of Special Enforcement. There's a link on the Office of Special Enforcement website, and it's here in this resource as well, that will lead you to the existing list of prohibited buildings. So if your building is on the prohibited building list, now you have to go on the off-ramp as well, and you can't do short-term renting. So if your lease prohibits it, or if you're on the prohibited buildings list, that's the end there. But assuming that's not true, let's go on to question 3. Is your apartment currently registered with the New York City Office of Special Enforcement for short-term rentals, and does it have a registration ID number? So in other words, it's time to register. There's a registration, it's time to apply. There's an application process on the Office of Special Enforcement website. It's a portal. They suggest that you gather the information you need for the application before you start filling in the questions. That makes a lot of sense. I believe there's an application fee of $145. Now, here's something at this point that I want to call out that I think could be a problem for a lot of people. And that is if there are certain hazardous violations associated with your building, the Office of Special Enforcement will reject your application. And here's the thing, the hazardous violations they're looking for are probably not going to be in your apartment, and they're not going to be something you can control. They're going to be things in the common area of the building that have to do with ingress and egress and fire safety. So what do you do about that? Well, the first thing I want to say about that is all New Yorkers are entitled to live in a violation-free building. So those violations shouldn't be there. It has nothing to do with short-term renting. You can contact the landlord and ask him to remove the violations. The thing with this is where I'm going to get pushback from people that they don't want to contact their landlord, but you really should be contacting your landlord. The Office of Special Enforcement suggests that you let your landlord know you're making this application, and I wholeheartedly support that. Short-term renting never should have been something that was being done surreptitiously behind a landlord's back. It should be out in the open, in the light of day, and so by all means, contact your landlord and talk to him about those violations. Here's the thing. Some landlords are going to be fine with this, believe it or not, because short-term renting brings in money and money pays the rent. It's really that landlords don't want to get in trouble themselves, and they don't want their other tenants bothered, which really brings us to question 4. My question 4 is, are you committed to complying with the law in the execution of your short-term rentals? So let's say you're somebody who's got the coveted registration number, you're ready to list and have your guests. This is where I could see it going off the rails and New York having a lot of the same problems it had before Local Law 18, after Local Law 18. And so I'm going to say 3 things that you need to be committed to doing to keep this in the bounds of legal. One is you have to be home when the guest is there, as we covered extensively in segment 1. Number 2 is you cannot have more than 2 guests. And number 3 is you can't alter the apartment to do this. You can't put up a wall and a door. You can't do that without your landlord's permission and the Department of Buildings permission, and you're not going to get it. So no altering the apartment to make this possible. So this is another thing. The short-term renting going forward is probably going to work for people with 2-bedroom apartments when there's nobody in that second bedroom. I know the universe of who can do this is getting smaller and smaller as we go down, but there are still some people left standing, and this is for them. And then that brings us to the final question, which is, are you committed to complying with registered host requirements? Because there's more to do now. This is a thing. It's like running a business. One thing, I'm just going to take one random thing on host requirements as a good example. You need to post some type of a diagram. There's more information about this on the Office of Special Enforcement website. You need to post a diagram that your guests can see that shows them how to get out in the event of a fire. There's just more stuff to do. You need to keep records for 7 years of your listings, of your bookings. You need to keep your records for 7 years. Now, everybody's in the cloud now. Storage is plentiful. It's not impossible to keep records, but it's going to require you to be organized on a whole other level because you have to keep these records. And I want to say another thing here about being a host in this section. And the Office of Special Enforcement doesn't hit this so hard, and it really has nothing to do with Local Law 18, but it's important. If you're going to engage in short-term renting on a regular basis, you should talk to your accountant. I'm not an accountant, I'm not a tax lawyer, but you're making money, so it's income, and I'm assuming this is taxed as regular income. However, I've seen articles in the press suggesting that perhaps this activity would be taxed as hotel tax. So, that could be a game changer. So you have to keep your eye on that. That's the point. It's more like a business in some senses. And Local Law 18 really requires that you up your game and your game should be there anyway because this is serious stuff. Okay, now I remind you there is another resource that I'm putting on the Tenant Law Podcast website that I created called 7 Tips for Stopping a Neighbor in Your New York City Apartment Building from Doing Illegal Short-Term Renting. So I'm assuming people are going to find their way around this and there's still going to be illegal activity. I mean, I know there is because there always is. And so I decided to create this resource. It has some really, I mean, some of it's obvious, but there's some cool tips on here. And that I don't know if it's going to be up when I hit publish on this, but it'll be up the next day. What I would like to know from you, audience, is who does this still work for? Who out there thinks they are going to be participating in offering their apartment for short-term renting legally? I have 2 ideas of where I could see it working. Number 1 is I'm thinking small self-managed co-ops. So a co-op with like 5 or 6 units where the shareholders live there and they're friends and they trust each other, and maybe you have an empty nester with an extra bedroom and they like people, and that's somebody it could work for. And then I'm thinking outer boroughs, bigger apartments, less management, maybe even I have in my head owner occupied buildings, like your landlord lives in the building and you know them very well, and you, like I said, short-term renting is going to bring in money and money pays the rent. So I'm thinking that for the people that it's possible for, because there's less of this activity now that's going to be prohibited out there, the prices for it will go up, and putting that together, so that might make landlords more amenable. But again, the name of the game is really do it legally on every level, which is going to require a certain amount of study on your part. The resource that we went over a minute ago is just a starting place. And the key is really don't do anything that's going to get the landlord in trouble, and don't bother the other tenants in the building. Think even of the name Airbnb. What's the B&B? People forget bed and breakfast. This all came out of the idea that it was a way to find a B&B, a way to go stay with somebody who would give you a bagel in the morning and point out where the park is the next day. It was never supposed to turn into what it turned into, which is why we get local law 18 and all the pushback. And look, I'm sure there will be so much more. Like, we're just starting. Every time they make a big change like this, there's so much going on. So that's another thing. Shoot me an email and tell me whether you like this content, whether you want more of this, so that I can know. Okay, so there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.